Okay. So whenever we are doing this class session చేస్తున్నప్పుడు, I request everyone to keep their barracks ready for reference,
Okay,
so
sir.
that it will be easy. నేను బేరాక్ నేను చూపెట్టే బదులు మీరే పక్కన పెట్టుకుంటే, బికాస్ నేను కూడా బేరాక్ పక్కన పెట్టుకుంటాను, నేను చదువుస్తుంటాను, మీకు అర్థం కాదు. You may not be understanding what I am doing. Okay.
Yes, sir.
So if you keep your barracks in your hand, you keep it with you, so it will be easy for you to read also, and same time you can tick with a pencil. Don't underline or write notes in the barrack until the examination is over. Okay, because sometimes some examiners will not entertain overwriting in the books. Okay, some examiners are there, they don't bother what you bring. Even if you take textbook also, they are not bothered, because they don't check also. Okay, some people they will check, so then you will have problems. Okay, so keep Bayrak ready in your hand, so that if I am talking about any definition, so it will be easy for you to understand what definitions I am referring, what definitions I am not referring. Okay, so how many of you are can you see the screen?
Yes, sir.
Okay, so how many of you are having Bayraks ready with you?
Yes, sir.
Yes, sir. Unnai, sir.
Yes, sir.
Unnai kada? So keep
Yes.
it in your hand, so that if I am talking, just open the book and you can see. Okay, so I'm starting. So CPC, Civil Procedure Code. I'm talking about introduction. This is basic introduction. You don't get any question. You will get a question, of course. Okay, there will be a question. This answer will be there in the. You can open your Bayrak. Okay, so when did CPC came into force? There was a question somewhere, I don't remember. This is one of the important question. It may not be for CPC also, it may be for all other subjects also, common for every act. When did it come into force? So they will give you 4 options, different options: 1st January, 2nd January, 10th January, so and so year. So you can find that in the first section itself, it shall come into force on the first day of January 1909. Okay, but it is called CPC of 1908. So they may give you 1st January 1908, 1st January 1909. So if you don't know how to look at Bayrak, you will write, okay, CPC 1908, so it will be 1908 only. So you'll write 1908 and come. Or it will be written given as 21st March 1908, because this act is passed on 21st March. Okay, but it came into effect from 1st January 1909. So that is the basic difference. Okay, so it is pre-independence law actually. So it is multiple laws were brought together, they codified. They want to have a uniform civil legal system, because there were different courts in before independence. Okay, earlier they were calling it Supreme Court, then they changed it to High Courts, but each High Court were different and they were having their own rules. They are independent rules. Then there were rules for separate princely states, independent states. So Bombay was having separate court and they were having separate rules. Chennai, Madras was having separate court. Madras was having separate rules. Calcutta was having separate court. Calcutta was having separate rules. So Madras presidency, they used to cover up to Orissa. So Andhra Pradesh, Tamil Nadu, Kerala, and some part of Orissa. They were under the Chennai, Madras province. So separate. Calcutta was separate. Mumbai, Gujarat, some part of Madhya Pradesh, some part of Pakistan, Lahore, Karachi, all those things were, I think, under Mumbai presidency. There was no New Delhi in those days. So Delhi came later actually. Even though Delhi was capital, Delhi was not presidency. Okay, so these 3 were controlled by British directly. So other places, they were de facto, they were direct here. So they were having their own courts in these places and they were having separate civil procedure. So they want uniform civil procedure for all these 3 places. So for that reason, they have unified in India in 1908. Okay. So this date is important when it came into existence, when it is passed. So it is passed in, you will find it in the first page of CPC itself when it is passed. So second will be Okay, so in the screen, the CPC was enacted and 1998 came into force on 1st January 1909. I gave that also. Okay, and it is not applicable extended to. Okay, it is also there. They may ask question also here. See, another important things. Forget about princely states. Certain tribal and scheduled areas which were governed by special regulations. Even now, there are one or two exceptions are there for CPC. So till certain period, even some parts of Andhra Pradesh agency areas, they used to call agency areas in Andhra Pradesh, Godavari and Visakhapatnam districts, there are agency areas. So CPC was not applicable for agency areas. Even now, some marriage acts are not applicable in agency areas. They are having their own traditions. So traditions are they are superior to these laws actually in some specific locations, and so they have given exceptions. Even for CPC, certain tribal areas and scheduled areas which were governed by special regulations. So this is not applicable. Okay. So applicability is also important. So here itself you can see, okay, in the part, if you are going through that, then state of Nagaland and the tribal areas. So Jammu and Kashmir was also there, but Jammu and Kashmir, now it is in India. So they have removed Jammu and Kashmir. So Jammu and Kashmir was also there before that. So you can see in relation to Amini Devi, East Godavari, West Godavari, and Visakhapatnam agencies, those things they have later on they have added. State government can add any place if it is not included. It is the freedom is given to the state government. Okay. So applicability, pan-India applicability came in 1951 when India combined after India became a separate republic. So it all princely state are merged in India. Pakistan and Bangladesh and East Pakistan, West Pakistan were separated. So it became applicable for entire country in 1951. Okay. So CPs, I will come to that next slide. I think see the Parliament can amend any part of CPC. Sections or orders. CPC is having sections and orders. I'll talk about it later. Okay. Parliament can amend any sections and orders also. Okay. The CPC is the only such thing where it is divided into two parts, sections and orders. So orders is for more convenience because it is different from time to time. There is changes are required. High courts and Supreme Court are given certain powers to modify CPC. But sections they cannot modify because sections are, this is part of the main act. Only legislature is having power to amend any section. But for that reason, if there is any emergency, they need to change some specific things. For that purpose, they have made it into two parts. One is orders part. Orders part, any high court can amend. Okay. In there, that amendment is applicable only in that jurisdiction. Say, let us say, if there is an amendment required in any order, Telangana High Court is passing that, it will be applicable only in Telangana. It will not be applicable in Andhra Pradesh. Okay, before bifurcation, any order is passed, it will be applicable in both states. But after bifurcation, any amendment to any order or any new order is included, it will be applicable only to that specific state. Okay. Then state government will notify that. Okay. So CPC is a procedural law. So how there are two things, substantial law and procedural law. So Property Act, Marriage Act, Contract Acts, Sale of Good, there are few acts, civil related acts, which are substantive laws, and this is a procedure law. To implement those things, we use procedure. Civil code, how to administer civil procedure, how to administer civil codes is regulated through civil procedure code. So civil procedure code is how to run civil codes, how to apply civil laws in those substantive laws. Okay. So what is the scope? The code is exhaustive on matters specifically dealt with it. It is not exhaustive on the points not specifically dealt with therein. the legislature is incapable of contemplating all the, see, this is very important point. Why they have made into sections and orders. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigation and consequently for providing procedure for them. With regard to those matters, courts have inherent powers to act according to the principles of justice, equity, and good conscience. Okay, so legislature is not capable of contemplating all possible circumstances. So what will happen tomorrow? What changes will happen tomorrow? They are not prepared in those days, 1908. So for that reason, they gave that liberty to courts through that inherent power, section 151 of CPC, where courts are having certain inherent powers. Through that only, okay, they can add to the orders, but they have to keep in mind principles of justice, principles of equity, and good conscience when they are framing any new order. Okay. So the court specifically provides nothing in this code shall deem to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for ends of justice or to prevent abuse of the process of the court. So courts, the High Court can change the orders, amend the orders, add new orders also. In event of conflict, special law would prevail. So if there is any conflict between the CPC and there is a special law, let us say Consumer Protection Act is there. So Consumer Protection Act is a special law. So CPC says something, Consumer Protection Act says something. If there is any special law on a subject, special law would prevail over CPC. Okay. If special law is silent, then CPC will prevail. Okay. If Consumer Protection Act says this is the rule you have to follow, then that is the only rule, even though it is against the CPC provisions. Special law will prevail over CPC if there is any conflict between CPC and that special law. Okay, consumer protection is a civil law only. Okay, there is no punishment. It is only penalizing, only penalty, compensation. So criminal law, there is a punishment. Civil law, it is the compensation. Okay, so that is, remember those things. So here, earlier it was part of civil law only, but they have made a special law, Consumer Protection Act, 1986. Then they modified, they have come out with multiple things. 2019 is the latest. So that law will prevail. Okay. Here, Civil Procedure Code is divided into, this is another question you can expect. Civil Procedure Code, how many sections are there? How many parts are there? Okay. Then how many schedules are there? All those things will be there. So there are 158 sections divided into 12 parts. Okay. Then the schedule is there, which is having 51 orders. And there is 8 appendices, which will contain forms and model formats. So this is very important. You can find out in the PAYER Act itself. Don't worry. You should know that index itself, you will know. Open the index. You will see how many parts are there. Go till the end. You can see till the sections. Don't go to orders. Okay. Before orders itself, you can go. Before the first schedule. Okay. Then you can come to the first schedule. The schedule is there. There are 51 orders in the schedule. I think I made a mistake. I think there are only 11 parts.
Yes, sir.
11 kada?
12.
12 unda?
11, sir. 11.
11 undi. 11 parts కనపడుతుంది నాకు అక్కడ. ఓకే, నేను టైపింగ్ లో ఎక్కడో మిస్టేక్ అయి ఉంటుంది. సో అదే రివిజన్ చేస్తుంటే మనకు తెలిసిపోతుంది. సో అందుకే మీకు నేను చెప్పాను అని చెప్పి 12 చేసుకోకండి. బుక్ ఓపెన్ చేసి రాయండి ఆన్సర్. యూ జస్ట్ ఓపెన్ ద బుక్ అండ్ కన్ఫర్మ్ అండ్ రైట్ ఆన్సర్స్. ఈవెన్ దో ఇఫ్ యూ రిమెంబర్, యూ మే రిమెంబర్ రాంగ్. Okay, so how many sections are there? You go to the last section. 158 is the last section. So 158 is, you got it right. Simple. Okay, then orders. You go to the orders in the index only. You go to the last order. How many orders are there? 51 orders. L means 50. Okay, L is 50. Roman L. You don't. I mean, don't mistake. L means 50 in
Yeah,
Roman
yeah,
letter.
total 51 orders are there.
Okay, 51 orders are there. Okay, then appendices are there. That is forms. So this is the scheme. Okay, how the CPC is divided. You got it? You will. They have asked 2 to 3 times question. This type of question you can expect in all topics: constitution, criminal procedure, BNSS, BSA, all subjects. They will ask this question. They will not ask in other questions. The subjects main subjects 5, 6 subjects they will ask. Okay, constitution, BNSS, BSA, BNS, civil procedure code. 5 topics they will ask. Major laws. These are 5 major laws. Okay, these 5 topics they will ask. 46 marks. They may ask 1 or 2 questions from the how many sections are there in this law? What is the last section? There are 158 sections, 140 sections. They may ask different things from such questions. So it is easy for you. Just go through the BARE Act, open the BARE Act, go to the last section, answer that thing. How many orders are there? 51 orders are there. Go to that last chapter. See how many orders are there. You can answer. Which order is having maximum rules? See, every order there are rules. Okay, they can add orders. In the orders there are rules. Okay, so each order contain rules. Okay, which order contain maximum rules? That is also they asked once. Okay, 21 is having 106 rules. Okay, order 21 is having 106 rules. It will take 1 minute if you don't remember this. Go through the rules, go through it faster. 106 is the 21. See if there is anything more than 106. If nothing is there for 106, then you write that as a 106 as the answer. Simple. That is the highest 21. Okay, this question is also asked. Which order is having maximum rules? Okay, so you can expect. So you should know why I'm giving emphasis on orders and sections, because orders are different. Sections are different. Orders can be modified by courts also. They can add any orders. Orders are different from state to state. Okay. Sections are universal. Orders, earlier few orders are universal for entire country, but state can modify some orders. They are having powers to modify high courts. Okay. Sections can be amended only by the parliament. Okay. This thing you have to remember. So here scheme of the High Court under section 122 to 127 and under section 129 to 131 are empowered to annul, alter or add any rules, and such act shall not be inconsistent with the provisions of the body of the code. Body of the code is, what is the body of the code? Provisions of the body can be amended only by legislature. Body of the code ante sections. Okay. Body of the code anedi sections ne body of the code antamu. Orders ni body of the code anamu. Okay, so if they are altering any order or they are adding any rule, removing any rule, it should not be inconsistent with the provisions of the body of the code. It should not be against the sections of the code. Sections ki consistent gaane meer emaina cheyochu. Deeniki against ga chesthe adi valid kaadu. You got it? Provisions of body of the code can be amended only by legislature. So here I made it very clearly. Body of the code means sections only. So under the sections 122 to 127, 129 to 131, high courts are empowered to alter, add, annul. Annul ante teeseyadam, alter ante marchadam, add ante kotta rule petadam. So annul, alter, add, mood cheyochu. Annul ante they can remove, alter ante they can change, add ante they can add new rule to any order. Even sometimes they will add new order also. Say there is one order. I'll just tell you what is that order. 20A is there. You can see that 20A. Okay, so instead of 20, they thought that they want to make new order. So instead of 51, 52 order, so it will be not proper because it is related to order 20 only. So they have made a special order 20A. So they can add new orders also, like giving, they can add it 52 or they can make it 20A, 22A, 23A, whatever it is they want. Okay, they can annul, alter or add any rules. Okay, they should not be inconsistent with the code. Okay, then this is section 2 of CPC. Definitions. Straight away you can open the book, see the answer. Suit, they will give definition. The definition of the suit, they will give something. Which section they suit is defined. Okay, what is included in decree? I mean, what is the section of decree? 2 in bracket 2. Okay, so they will ask such questions. You just, it is alphabetical. Simple thing is, don't worry. The definitions are in alphabetical order. So you need not worry. You can go alphabetically. If say they are talking about order, it will be MNOP. O. Okay, you can see O. Order means a formal expression of any decision. Which order, which section, which subsection, it is there clearly. Be careful. Just go through this and you can directly answer those things by opening the definitions clause. Okay. Index, you cannot answer these subsections because index is only section 2 definitions will be there. So you have to open the BARE Act, go through this list. So you can answer there are around 20 subsections in definitions. Okay. Section 12 is important. Mean profits. This is it is a concept-based question also. Foreign judgment is also foreign concept-based question. MESE, MESNE, MESNE. Don't spell it MESNE. MESNE. MESNE kaadu. Mean. MEEN and ankondi mind lo. MEAN ankondi. Whatever you want. MEAN. Let me say simply MEEN or MEN is the correct spelling. If you want to spell that, mean profits. Okay. Mean is not an Indian word or English word. It is a French word. It is a say mean. Okay. Arithmetic mean you studied in mathematics, right? Arithmetic mean and chautam kada. It is average, something related to average. So mean profits is related to some extra profits. We will talk about the definition. I'm not keen in going that one. I'm talking about that thing. It is derived from that word, French word. So English we call it mean. So it started. We are using French word, but we are pronouncing it as a mean only. We have changed that arithmetic mean. We changed it, MEAN. But when it comes to law, we didn't change that. We are using the French spelling only, but we are spelling it as a English word. So that is the only change. Mean profits. So don't mistake if somebody says mean profit means spelling is MESNE only. Mean, 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 arithmetic mean. Remember from that one. Okay, that is a French word. So these are the definitions. All these definitions you can get it in the definition this thing itself. Okay, so these are the topics. Basically, see, as I told, it is a procedural law. So what this procedure is used? It is used for recovery of money, possession of property, injunctions, declaration, partition, compensation, specific relief, or for contract. Basically, specific relief related to contract, where somebody, you entered into a contract, the contract is broken, they have not fulfilled the obligation. Then under specific relief, you will file a suit for them to fulfill their obligation or for paying compensation. That is a specific relief act. Okay, it is purely related to contracts only. Specific relief. So normally, lot of books will be contract and specific relief is one book only. Avatar Singh is the famous book. You can go through that if you are having time. But for contract, I request you to go through textbook. Your LLB textbook is enough. Just for some concepts you have, it is required. Okay. There are certain serious conceptual related questions in contract. Okay. When we come to the topic, we'll discuss. Okay. Now definitions are over. So then there are about the courts. We'll not talk about courts because we have discussed about courts in the initial stages. I gave the list: civil courts, criminal courts, the definitions, and what I mean, their jurisdictions. About those things I have discussed in the introduction itself. If you have missed, it is there in the YouTube. You can go and refer. Okay. So code definitions, civil codes, criminal codes, hierarchy, all those things are there till section 8. Okay. Then section 9, it comes to suit. This is the part 1 actually. Here part 1 starts actually. Till section 8 it is called preliminary only. So suits in general is the part 1. So here it is part of the section 9. It is very important. What is the jurisdiction here? The court shall have, subject to any express or implied bar, have jurisdiction to try all civil suits of a civil nature. Okay. All civil suits of civil nature. See, this law is passed in 1908. We have to remember that. Okay. Then we'll come to that. So, and how carefully they have mentioned it. Subject to any express or implied bar. So, they can try any civil case until unless there is some bar. Okay. Express or implied. Express means it is in writing. Implied means understood through our behavior and attitudes and our communications, other things. It is implied means, okay, you should understand by the behavior of the things. Okay. Until unless there is a bar. All suits, so involving civil right, not expressly or implied barred by law, can be brought as a civil suit. Okay. What is civil suit? Anything affecting private right and having remedies for that. Okay. So, expressly barred, that is the reason I told this is passed in 1908. After 1908, many new acts have come. Okay. Like, as I told, Consumer Protection Act, it was civil act only earlier. Then Competition Act is there. Company law is related. Company law is this was under civil. Okay. Then marriage related was also related under civil. So just I'm giving some examples. Even maybe income tax related was under civil. I don't remember that. So now what happened? There now separate tribunals are established. Separate courts are established for some cases. Like income tax, you are having a tribunal. Company law, you are having a tribunal. Okay. Consumer cases, you are having a separate commissions. So here they have expressed that separate law is made for separate activities. So if there is any civil rights affected in those areas, it will not come under civil court jurisdiction. Okay. Because otherwise earlier everything was coming. So any new act has come, special courts are they have come. So here any time expressly new law is coming, so that new law will prevail over CPC. In that particular area, company law tribunal is there, company law tribunal is there, company law appellate tribunal is there, then company law, if last they will go to Supreme Court. Nothing happens. Commission, District Consumer Commission, State Consumer Commission, National Consumer Commission, then Supreme Court. There are certain cases which can come to High Court where it is related to law. That is, otherwise it will not come to High Court. It will go to, because Supreme Court is the last and highest appellate court in the country. So all finally they have to go to Supreme Court. Civil, criminal, everything goes there. Even tribunal related also, all goes to that thing. Administrative tribunals have come. Labor tribunals have come. Labor courts are their separate courts. Okay, so all these courts, they are established in later stages. So earlier they were tried under Civil Procedure Code. Until, so that is the thing. Those things, except those things where special express or implied bar is there, all those things come under Civil Procedure Code only, civil courts only. So this is another important point. This is concept based also. So that is the reason I made it separate slide. Stay of suits. This is section 10. So section 10, certain there is a stay for certain suits. Okay. That is res sub judice. Okay. Res. This is Latin word meaning matter, a thing or a matter. Sub judice. This is also Latin word under consideration or pending judicial inquiry. Sub judice. So if there will be some discussion happening, they will say we will not comment because it is sub judice. Because it is pending under judicial inquiry. Judicial inquiry is going on, adjudication is happening, case is running. So we cannot comment on those things about the judgment outcomes of those cases. So it is called sub judice. So res sub judice is the concept, means pending litigation or pending adjudication by court. So if there is any matter running in a court, you cannot file a fresh suit before any other court. Okay. And with the same parties and the same title and the same cause. Okay. It cannot be filed in that court or any other court. If something is running, you feel that it is getting late, so let me file in another court. Say civil cases, we will talk about it in next couple of slides, or I'll tell you separately. See, if there is a property related dispute, there are two properties. You can file any one of the court. One is in, say, let us say in Hyderabad district. Another is in Rangareddy district. So you can file the case in City Civil Court, Hyderabad, or you can file that case in Rangareddy District Court, Civil Court. So you can file in any one of those courts. Okay. But you can include two properties in that case. It's just because you are having two separate property, one property you file case here, one property you file case there. No, you file for in one jurisdiction only, one court only. Now, it is going slow. Our judge is temporary leave for long leave, whatever may be the reason. Now you want to file the same case with the same cause title, same topics, everything in Rangareddy court, because there is one property there also in Rangareddy jurisdiction comes there. You want to file there? No, you cannot file because it is sub judice. That is the concept, res sub judice. Stay on suits when there is a pending judicial inquiry in some other court. You cannot file. It is against law. Okay. So that is stay on suits, res sub judice, section 10. There is a bar. If some case is filed in some other court, they cannot file. Res judicata. This is another concept. Okay. Res judicata, there already case is not decided. Here case is decided, judgment is given. Okay. Res means matter, judicata already decided. Res judicata, a matter that has been already judged. Okay. So section 11 says, once a matter has been finally decided by a competent court, the matter cannot be reopened or relitigated between the same parties. Okay. Same parties, same matter, they cannot reopen. Okay. That is res sub judicata. Section 11 says that. Okay. So section 12, yeah.
Sorry, sir. Sir, then what is the point of appealing, sir? Does this mean
appealing is different? See, appeal is
a person
different.
cannot appeal?
Appeal after, say, appeal duration is also over. So you are not appealing. So you are appealing in the similar court only. You are not, appeal is in the higher courts. Instead of appealing, you are filing the same case in some other court. You got it?
Okay. So higher courts it is allowed, but same level
Allowed
courts
if
it
it
is not allowed.
Yes, appeal should be allowed, and appeal should be in limitation period only. Okay, appeal should be in limitation period only. You cannot file appeal after 1 year, 2 years, 3 years in some cases. You cannot file appeal after 12 years in some cases. There are certain limitations period for filing an appeal. Okay, so limitation law you have to know. Based on the limitation law, you have to file the appeal. And appeal should be allowed. If the appeal is not allowed, you cannot file an appeal. Say, let us say there are certain cases. Say there is a penalty of 100 rupees imposed by a small court. Let us say 100 rupees. You cannot go for appeal in that cases. Okay, there is bar beyond 500 rupees or less than 500 rupees. You cannot appeal. Less than 1,000 rupees, you cannot appeal. There are certain cases where appeal is not allowed.
No, sir.
Okay.
My question is, how is appealing an exception to res judicata?
Res judicata is in the same court, same party, same new case. I'm talking
Same
about
court,
new
okay.
case. You cannot file a new case. Appeal is not a new case. Appeal is not a new case. Appeal you are filing against the judgment of the lower court. See, appeal is filing a judgment, fighting on the judgment. This court has given, district court has given judgment. I am not happy with the judgment. There is some flaws in the judgment. So you are going for the appeal.
Got it.
You got it. So now what you are doing? City Civil Court has given against me, so I'll file a fresh case in Rangareddy District Court, same caste title, same parties, everything same. That is not allowed. అర్థమవుతుందా నేను చెప్పింది?
Yes, sir. Yes, sir. Got it.
Okay. See, this is little bit confusion. Section 12. Okay, that is the reason again I am talking about section 11 and section 12. Don't get confused. So if some case is dismissed, you can't file again. That is section 12. You can't refile. Okay, section 11 says already decided. Okay, section 11 says if it is decided, judgment is given, you cannot file same case in other courts. Okay, from the beginning, you can go for the appeal. Same time, if the case is dismissed also, you cannot file. Okay, here it applies to plaintiff and defendant, section 11. Already decided, plaintiff cannot file, defendant also cannot file. Here it is the plaintiff only, section 12, because dismissed, plaintiff files the case for relief. It is dismissed, again the plaintiff cannot refile that same case again. Okay. So now it is place of suing the case, section 15 to 21. Actually, I didn't prepare slides for that one. There was no time for me. So I'll just discuss about that one. As I told, one more important thing. So where you have to sue is, you have to, section 15 says, every suit shall be instituted in the court of the lowest grade competent to try. So lowest court. So there are 2 courts which can try, 3 courts which can try, but you have to file the case in the lowest court. If JCJ can try that case, don't go to the principal civil judge or district judge. You have to file in junior civil judge only if it can be that comes under jurisdiction C. District judge, all suits will come. Principal civil judge, most of the cases will come. Okay, except few cases. Junior civil judge, only certain cases will come. So if that case fits into junior civil judge, you have to file in junior civil judge only. You cannot go to principal civil judge, because principal civil judge is also having jurisdiction to try cases. Okay, so you cannot go to higher courts. You have to first go to the lowest court where it can be tried. That is 15, section 15. So section 16 says, suits to be instituted where subject matter situate. Okay, where the subject matter situate. If there is a suit recovery regarding immovable property, you have to file where that immovable property is situated. If the property is situated in Hyderabad, you have to file in Hyderabad only. You cannot go to Chennai and file a case. Okay, but if you are having 2 properties, one in Chennai, one in Hyderabad, you can file in any one place. Not 2 places separately. You can file in any one place. Same thing to the partition also. Where the property is situated, you have to this thing only. Okay. Then if it is movable property, where movable actually where the contract happened, that is another important related to contract or sale of goods. It will be in the place where the defendant reside, or where the property lies, or where the contract is entered. It can be in any 3 places. Okay, I am selling a product. The contract is entered in Hyderabad. You are buying it in Chennai. So it is executed in Chennai also. So defendant stays there. So you can file case in Hyderabad, or you can file in Chennai also, where the defendant stays. So suits of, if that's what I told, if it is situated in different courts also, you can file in any one of the court. So so section 20, I already told, where the defendant reside or cause of action arose. So if the cause of action arose in Hyderabad, so you can file in the Hyderabad, or if the defendant is staying in Chennai, you can file in the Chennai also. Okay. So bar to set aside decree on objection of place of suing 21A, because this is 21A is once the court already start adjudication or started the trial, you cannot challenge validity on the jurisdiction once it started. You have to start in the first instance itself. when the court starts taking the case. Okay. So now